in the private placement memorandum why you are raising that money. So when the guy comes up to you and says, look, I'm going to sue you. You told me that if I gave you this money, I'd own part of the Brooklyn Bridge. You said, no, we've had this conversation 10 times. You're giving us the money so that we can have the lights on the Brooklyn Bridge. But this is, this is nothing about owning the Brooklyn Bridge. I says, I don't care. Pay me or I'm going to sue you. You say, go ahead and sue me. I'll take the private placement memorandum in there and make it clear to the courts that this is what the money was for. Okay? So because of the threat of litigation in this country, which, as you know, is a big problem. John, could maybe you step outside or get away from the microphone so we're not picking that up? This is one of the reasons why we have Section 10B, or private placement memorandums. Now, what else was I going to mention about this?
What about oral representation?
I'm sorry?
Oral representation, that's not.
Yeah, you can have oral representations held up in court, but I believe, and I'm not a lawyer, if you have somebody come to court and say, well, he told me verbally that I would own the Brooklyn Bridge, but you're able to provide a legal document, the private placement memorandum, which states that in fact the money was just being used for the lights, well then the legal document will trump that. The Investment Companies Act of 1940, all right? This is the law which is used to regulate asset managers. So everyone here, I'm sure, is familiar with Fidelity, is familiar with Alliance Capital, T. Rowe Price, the big money managers, okay? They are required to register their funds with the SEC, just like a company registered with the SEC as well. I once worked at Alliance Capital where I was a portfolio manager, and we had to file the documents with the SEC when we raised money for a healthcare fund. Okay, and in there's all the disclosure of risk factors. There's all the disclosures of use of proceeds. All right, and you file it with the SEC. Anyone here figure out why it is that so many hedge funds out there are not registered with the SEC? How it is they get around the Investment Companies Act of 1940? The Investment Companies Act of 1940, like most pieces of federal legislation, has two exemptions.
Isn't it for investors that invest over like $1 million?
What you're thinking about is whether or not they're accredited investors. Most pieces of federal regulation have two exemptions. One is for state exemption. Okay, if a transaction is done solely within the borders of a state, the federal government cannot intervene. Okay, in this country, as you know, we have a lot of history with states' rights versus federal rights. We fought a civil war over it, at least according to the South. If something is happening entirely within the borders of the state of South Carolina, the state of South Carolina will say justifiably, why is the federal government regulating this? And therefore, most laws are passed with an exemption for insured, yes, within the borders of a state. The other exemption is size. The SEC, like most federal agencies, all federal agencies, have limited budgets. Okay? And therefore, they are unable to police all transgressions. So one of the things that you do is you say, oh, like, all right, only investment companies with a certain amount of assets will fall under this act. And in this legislation, it was written a certain number of investors. So if you go in and you take a look, there are two exemptions in Section 3C1 and Section 3C7, which designate if you have more 99 investors or less, you are exempt. Okay? And so what you'll see with many hedge funds is they will start up a fund, and when it gets to 99 investors, they shut down registration. And then they'll start up Fund 2, which will have the exact same investment parameters. We'll invest money in the same way, in the same types of stocks, with the same portfolio manager, but it's called Fund 2. And now you raise money from 99 more investors, and then you shut it down, and you start up Fund 3. Okay? This shell game is one of the things that people do with federal laws, because federal laws will put in a clause The clause will be interpreted by the executive branch. The marketplace will squabble with the executive branch over its interpretation. It will end up in the courts and the judges will rule. Once you have a couple of legal rulings on how you interpret a certain part of the federal legislation, now everyone's free to exploit it. So if you ever take a look at your retirement account, everyone has a 401k. 401k is a section of the U.S. Code. All right, it got interpreted such that 401k means that if you take that money and put it into a retirement account, you don't have to report it on your income taxes to the IRS. And when that was put in there, it wasn't necessarily meant to be that way. The section 401k of the U.S. Code got interpreted by an accountant. I forget his name. I believe he was in Pennsylvania. And this fellow said, wow, I think the way we can interpret this is that if you put money aside into this account, it doesn't have to be reported on your taxes for the IRS. Went to court, the accountant won. And now it's a $100 billion plus industry, right? So here with the Investments Companies Act of 1940, this act, like most acts, creates an exemption for states and for size. But in creating this exemption on size, it did it by the number of investors, not the size of the assets. When you take a look at big companies, right? KKR, I think now it's going public, Carlyle's gone public, but there are a lot of big private equity firms out there that are private. They're not registered with the SEC. They do the same thing. Just keep 99 investors and you don't have to register. The next slide, the Investment Advisors Act of 1940. This regulates professionals who give investment advice with exemptions created for different specialties like lawyers, teachers, etc. And basically what it's supposed to do is prevent the so-called snake oil salesman from running around and talking investors out of their hard-earned money and having them invest in companies that aren't worth anything. So on the one side you have the Securities Act of 1933 trying to make all information available to investors. Okay? Then you had the Investment Companies Act trying to regulate the folks that were aggregating the money to invest. And then finally with the Investment Advisors Act, and it's funny here, they spell advisors, I think, with an E in the act, even though I think we use an O now. But with the Investment Advisors Act, you're trying to get the people who are running around and talking grandma out of her, last $1,000 to put it into a biotech company or something very risky, right? And so with this, you've created a law which is now used to cover people like research analysts or stockbrokers. People have to be registered, and they register now through the NASD or the National Association of Securities Dealers. So let's move forward. We move forward now to Sarbanes-Oxley. Okay, and I should actually just go back 1 second here. On the Investment Advisors Act of 1940, again, we are defining public equity, all right, in order to understand the boundaries of public equity, because private equity is everything else. Okay, in the Investment Advisors Act of 1940, there was a Supreme Court case which ruled that if you have an investment newsletter, you can offer opinions through an investment newsletter and not fall under the Investment Advisors Act of 1940. So there are a lot of people now you'll see that will have investment newsletters, that will send out investment advice, and the SEC can't touch them because of that Supreme Court decision. Okay? So for every law, there's a way of getting around it, and there's ways of getting around the 33 Act, which we will discuss. There's ways of getting around the Investment Companies Act, which is have 99 investors or less. You're a private equity fund or a private equity fund. And there are ways of getting around the Investment Advisors Act of 1940, which is put it in a newsletter. Blast out the email. Sarbanes-Oxley. So and the other thing I'll point out here is a lot of these laws are passed after a moment of great trial and tribulations in the marketplace, right? So we had the stock market crash in 1929. What happened after the collapse of 1929? Well, we had the Hoover administration kind of plodded along for 3 more years, didn't do anything, and then FDR came in, and in the opinion of some people, overreacted with the security